Derek Chauvin still in trial. We're on day 23 now. The government had 3 additional witnesses in court today. We've got a lot to get to. Quite frankly, before we get into it, not that interesting of a day. We're sort of at that point. Today, I believe, was really the last day of the prosecution's case in chief. So starting tomorrow, I'm not real clear on this yet, but tomorrow we may see the defense present some of their experts, because I think today was the last witness. There may be one other witness tomorrow morning from the prosecution, but then we're going to change gears. They're going to rest. And then the case in chief is going to start from the defense, and there may be some rebuttal witnesses and sort of a second round of witnesses that come later down the pike. But right now we're getting close to the end of the government's case, and it feels that way. It just sort of feels like we've already heard this stuff. We've already seen this. I think today was our 6th expert to come in. Our last third witness was our 6th expert to talk about use of force and reasonableness and all of that stuff. And so even when I was watching it, I was like, well, didn't somebody already explain this like 2 or 3 times? Why are we listening to this again? And I'm wondering if the jury is going to feel that way also. And so let me go back to the trial board, as is usually the case. Today we saw a lot from Steve Schlucher down here at the bottom. He did some cross-examination and some direct examination. We're still in the government's case in chief today, even though we're wrapping it up. So it's still their turn to present their evidence. And Steve Schlucher, I think is how he says his last name, was in court today most of the afternoon. This morning was Mr. Blackwell, who was direct examining the cardiologist from Northwestern University. So we also talked a little bit about Maurice Hall. Remember Maurice Hall? This fella was the guy who was in the car with George Floyd, and about a week ago, maybe 2 weeks ago, he was in court. He appeared via Zoom he was still in custody. He's been picked up on an old warrant, but people are asking about this guy. Is he going to come in and testify? He was in the car. He can easily describe what George Floyd was going through, some of his mannerisms. He can even testify whether or not he sold George Floyd drugs, because we know that George Floyd's girlfriend was the person who said in court that they had previously bought drugs from Maurice Hall. And so both sides, everybody's been sort of on pins and needles wondering what's going to happen with this fella. And so he was also in court today. Before witnesses even started, I want to go through 3 issues that sort of were addressed first thing this morning. We're going to get through them quickly. So number 1, the first issue that Eric Nelson brought up, and again, Eric Nelson is this defense attorney over here. So he was in court today saying that they wanted to preclude one of the government's witnesses, who goes by the name of Stoughton, from testifying today. So this, I think, is the 6th use of force expert. So Eric Nelson this morning said, hey, look, we've already heard about this stuff. We don't need any more use of force experts. We've already got 5 other people. What do we have this 6th person coming into court? So he tried to get him thrown out. Judge said, no, well, it's different enough that it's still relevant. And so they finagled that in. And so he came into court and he testified today. So that was pretty quick and easy. Got that one out of the way. Then we wanted to talk a little bit about the Dante Wright case. So this new Wright case that popped up on Sunday. Obviously, this is happening out of Minneapolis. We have a whole separate segment we're going to do on that story. But because it's happening in such close proximity to the George Floyd trial, Eric Nelson brought that up in court today. He said, listen, there are protests, there are riots. This all happened right around the corner, and we're a little bit concerned that this might jeopardize the trial, Judge. Do you think it's appropriate for us to continue forward now that there was another police shooting? It was presumably a white officer on a black male, very similar to this trial. We already know that the entire city is kind of walking on eggshells given the situation in this trial, and it just kind of happened very similarly again, and people are also upset about this. We have jurors who are traveling back and forth across the city to get into court to come in and be a part of this process. So what are we going to do if they're freaked out, they're scared to death because of what's happening? And I'm going to show you pictures when we get to that segment about what is going on. So Eric Nelson comes out into court today and he says, hey, Judge, we got to do something about this. So how about I propose 2 solutions? Number 1, we just sequester the jury. The jury's already going to be sequestered once they go in for deliberations, which should probably be Monday, according to the judge's timeline. Eric Nelson said, we got to do that right now. The media is going hog wild over this thing, seeing it all over the internet already, seeing a lot of people just spring-loaded, ready to pick sides. Got a lot of people on one side saying, hey, this was an officer. He shouldn't have left. He shouldn't have fled the scene, whatever. You on the other side, you're saying, hey, she shouldn't have shot him, right? People are just polarizing immediately. that's happening right now in the middle of the George Floyd trial where people were already polarized. So how can you expect jurors then to make sense of everything that's going on? So Eric Nelson says, we got to sequester them. We don't want them to see any of this media, lock them off so that they are sequestered. Judge Cahill said no. Eric Nelson also said, hey, well, how about this then? How about we do voir dire again? We call them back in and we go through a separate round of questioning. Just like what happened when the city council settled the case for $27 million with the Floyd family. Remember, we had a separate round of questioning. I think at that moment in time, we had 7 jurors who had already been selected. They called them all back in, said, hey, have you seen the news? Can you still be fair and impartial? And on and on and on. So Nelson, what he's just doing is sort of laying down the framework for an appeal, for a mistrial, just sort of raising these objections, probably knowing full well that Judge Cahill was not going to grant them. The judge is, as I've said repeatedly on the show, this judge is keeping the train on the tracks. He wants to get this trial done and over with. And so there's very, very little at this moment that is going to rattle him or knock him off course for that. So that one was also dealt with. Trials moving forward. None of the Wright case stuff, none of those developments seem like it's going to throw this trial off one way or the other. Then the last issue, the big one. Before we get into the clips, we got a lot of clips. Before we get into it, we're talking about Maurice Hall. So Maurice Hall, as I mentioned earlier, was the passenger in the vehicle in the car, and it's getting close to him testifying. Okay, if the defense now is going to start presenting their case as early as tomorrow, one of the people they may want to call is Maurice Hall. He was in the car with Floyd. Kind of an important witness, right? We've heard from a lot of other people, a lot of other bystanders on the side of the streets, people who were just walking by. They all came into court and talked a lot about it. We spent almost the whole first week talking to those people. So the question is, from a defense perspective, if you're Derek Chauvin, how can you complete a fair trial without having somebody that you want to ask questions about coming into court and testifying? Well, Maurice Hall, and before we get there, Derek, that's a pretty big interest, right? If you're a defendant and you're being charged with a crime, kind of important that you get to call your witnesses and present that evidence. So very compelling. Part of due process in a fair trial is you get to present the evidence that you want to present. Otherwise, what good is a trial if you're not able to present any evidence? So from a Chauvin perspective, very important to get Maurice Hall into court to testify. Maurice Hall also has a pretty big interest against testifying. It's called your right against self-incrimination, one of the most fundamental pillars in our Constitution, nestled right in there in our Bill of Rights. Very important. Against self-incrimination. So Maurice Hall is not going to be invoking that and saying, I'm not going to testify. So what Eric Nelson said, well, if he's not testifying, or if he is trying to invoke his right against testifying, against self-incrimination, Eric Nelson this morning said, all right, that's fine. If he's going to invoke all the time, then how about this? How about we admit his question and answer statement? Because he's given other interviews before. Right after this happened, in fact, he gave an interview, and Eric Nelson said he answered a bunch of stuff there. So how about we just go through that and just, instead of him testifying, we just submit this document and everybody can read it. Well, the judge came out today and said, no, that's not happening either. So there's still, questions about what Maurice Hall, what his testimony is going to look like, how it's going to be comprised, what's going to be a part of it. We don't know yet, but we certainly know as of today that written statement or prior conversations that he had with other investigators is not going to come into court. And so that kind of got out a lot of the threshold issues, the early morning issues. Then we got into the witnesses. So let's take a quick look at who we had today. If you recall, last week we finished off with the emergency room doctor, the pathologist, and then the autopsy doctor, Dr. Baker, the same guy who signed off on the death certificate. So we finished up with him on Friday, and you're going to notice that he was kind of one of those guys that was not like the others. We saw pulmonary doc said asphyxia. We saw emergency doc said, I think he said asphyxia too. Pathologist said asphyxia. But then Dr. Baker came out and said, nope, not low oxygen, not asphyxia. In fact, it was a bad heart that gave out at the last minute. So last week we were sort of asking ourselves, which one of these things just doesn't belong here? And Andrew Baker, of course, was the guy. He said this was a heart problem, all heart problems. And this was something that the government today brought in a heart guy to come in and rebut that, of course. So this guy comes in, and his name is Dr. Jonathan Rich is this fella. And so he testifies first this morning Then we go over to George Floyd's brother, who came into court this afternoon, and we're going to hear from him very briefly. He described a little bit about what hooping is, and so we're going to learn more from him. Then we have this fellow over here. This is a law professor, an actual former police officer who came into court and testified. A very big, renowned Stoughton is sort of a use of force expert, and he came in today, and he may be the government's last witness. Not sure if there's going to be anybody else that they want to just sort of wrap things up with tomorrow morning, but it's sounding like once we hear from Judge Cahill that they may be done for their part of the trial. And so that's who we're going to get into today. As I mentioned, we're going to start with Jonathan Rich. He is a cardiologist, and like other expert witnesses that the government has proffered thus far, very, very good resumes, okay? Like the best resumes, like outstanding. Northwestern, this, everything, teacher, professor, clinical, residency, all of it. And I'm not going to spend much time on that because he is very credentialed. Everybody in this trial has been extremely well credentialed. Basically, the top 1% of the 1%, they are the renowned experts. So this guy is not any different than that. But he comes in and he is walking us through the heart. Okay, he's a heart doctor. He's a cardiologist. And so if you recall, last week we spent a lot of time talking about Dr. Andrew Baker, who said specifically that when they did the autopsy of George Floyd, they took his heart and they dissected it. They analyzed it. And he saw that there were some major heart problems, some serious complications. And on the show last week, we were sort of trying to identify and analyze how these different expert witnesses were going to characterize Floyd's cause of death. Remember, you have the cause of death, you have the mechanism of death, and so largely it was a result. The previous expert witnesses had said the mechanism of death was low oxygen asphyxia. Dr. Baker came out and didn't say that, didn't even mention any of those words. He said cardiopulmonary arrest, complicating the law enforcement subdual, neck compression, all of that stuff, basically saying that the heart just gave out. Didn't have anything to do with the lack of oxygen or low oxygen. The heart was very hypertensive. It had a lot of, arteriosclerosis. It was just not in a good shape. And so the pressure combined with the adrenaline flowing, with the breathing, with the physicality was too much, this doctor said, and that caused George Floyd to die. So you've got three experts who are going one direction. You got Dr. Baker going a different direction. So what does the government do? Now you've got some incompatibilities. You've got some inconsistencies. You can't connect the two together. So today, what they do, they brought in a cardiologist to come in and say, oh, no. It's not the heart. The heart's totally good. The heart's fine. Nothing to do with the heart. Remember the low oxygen asphyxia thing? That's really what it was. And so this guy comes in and he goes and he concludes exactly that. It wasn't, in fact, anything to do with the heart. This was low oxygen and asphyxia. So here is Dr. Rich.
Have you formed any opinions in this case to a reasonable degree of medical certainty as to the cause of Mr. Floyd's death?
Yes, I have.
Would you tell us your opinion or opinions?
Sure. In this case, Mr. George Floyd died from a cardiopulmonary arrest. It was caused by low oxygen levels, and those low oxygen levels were induced by the prone restraint and positional asphyxiation that he was subjected to.
All right, so, right, we've heard that 4 times, 5 times, many times. And it was the same thing. So he came out, did the same thing, same cross-examination. What about this? And what about this? And yeah, well, yes, but, and so it was very boring. We've already heard all of this. I'm not going to go through it again. One good part on cross, if I had to guess or venture one, would be something that we've already heard before. It's when Eric Nelson asked him, what level of methamphetamine is safe to use? None, he says. None, right? None. Okay, great. So it's more heart conversation, more of the same, nothing really consequential, nothing I saw that would really change the game or move the needle any direction. Then we change gears. We go over to Philonese Floyd. This is George Floyd's brother. So he came into court today and testified. There's a doctrine in Minnesota called the spark of life doctrine. So you can bring in somebody who doesn't really offer anything of any evidentiary value, right? He's not coming in today and talking about toxicology or George Floyd's, diet or anything like that, right? To give us any guideposts on what was the cause of death or anything like that. He comes in and he just talks a lot about George Floyd and about their relationship and about their mother and about their experiences together. And then he explains something we're going to get to in a minute. But the government is offering a lot of this stuff. Emotional testimony, emotional conversation language. This is a picture. This was an exhibit 284, that the government, talked him through. He said, hey, this is my mom. This is Floyd. And they go through this whole narrative of, I miss them both. I miss them both. I miss my mom. I miss my brother. And this was a tragic thing, and it's emotional. It's emotional. Okay. It's not easy to lose somebody in your life. Hopefully you don't have to experience that anytime soon. If you have, you know what I'm talking about. It's not easy. So he is, going through this conversation and sort of, creating this story about where they came from and how big of an impact this has been. And it's all part of this spark of life conversation, right? You don't want to put up a bunch of witnesses, witness after witness, to talk about what a great person he is. Same reason you wouldn't want to do that with Chauvin. You wouldn't want to put, 20 other officers on the stand and say Chauvin's a great guy. It's kind of irrelevant, right? It's nice to know a little bit, but you don't want the court to be overly burdened with that. What is critical to finding the legality conclusion here, the legal conclusion? It's not about, puffing up these big stories. Anyways, Minnesota gives you the opportunity to do that. It limits it. And so this was their witness. This was George Floyd's brother, Philonese Floyd. And he came in and he tells a story about Floyd and their family. So he was there today. And the government also used him to explain something that we've heard kind of a lot about. It's this concept of hooping. Okay, hooping. So if you're not somebody who's familiar with this, it can mean a couple different things. It can mean, playing basketball, going and shooting hoops, right? Something I did a lot as a kid, shoot hoops. Hoops. There's another interpretation of hooping, which is ingesting drugs rectally, because it's kind of like a hoop down there, right? So you can go on urbandictionary.com if you want and plug it in there, look up hooping, and you're going to see two different definitions. You're going to see playing basketball and the other one, the less pleasant sounding one. They're both on there. And so there is a portion of George Floyd in one of the videos, I think one of the body camera videos, where an officer asks him what he's been doing. And he says on there, I was hooping earlier. Well, what is he talking about? What definition are we talking about here? Is it the shooting hoops or the other one? So people are, this is going to come out in the defense case. So the government's trying to blunt that. They know where this is going. So here's a question and an exhibit that were specifically prepared to blunt this theme. Government knows this is coming. So before the defense gets an opportunity to present their version of this, they're trying to keep this thing sort of contained. Here is Philonese Floyd talking about George Floyd and hooping.
All right. You indicated that your brother was number 5. Is that on the far left?
Yes, sir.
And South Florida, was that a community college?
South Florida was a community college. I'm looking at it. I noticed a whole bunch of the ball players because I met a lot of them coming up.
Did George Floyd maintain his level of fitness and love of basketball throughout his life?
Yes, sir. He loved to work out. He loved playing basketball. He loved teaching people the game of basketball. That's, to me, where I really learned how to play from him, because he guided a lot of guys on the court and showed them what they need to do to be better.
And when he would talk about playing basketball, would he use any particular term or phrase?
Oh, he said, hey, man, let's go hooping. And we will always say, come on, let's go. We always went hooping, and you have to hoop every day, because if you don't go and shoot a whole bunch of shots, like 50 to 100 shots a day, my brother will always say, you'll never be able to compete. Hooping was big because Magic, you had to watch the stars. We watched Michael, we watched Magic, we watched everybody hoop every day.
All right, so you heard the man's testimony, right? This is one of those things where the jury gets to decide credibility, whether you believe that that's a thing or not, whether they were hooping or not, right? Hooping, you got to hoop every day, is what he said. And if you go out there, you want to shoot 50 to 100 hoops every day in order for your hooping session to be effective. Otherwise, you're not going to be able to compete. So I've shot hoops in my days, and 50 to 100 shots is not that much. Okay, you can get through that in like 10 minutes, really. I mean, just do the math on that. 50 shots. Can you shoot 5 baskets in a minute? Easily, right? That's what, 10 minutes to shoot 50 baskets? It's not a real long hooping session, right? Jordan used to go out there and shoot 1,000 free throws every night. 1,000. That's different. Not 50 to 100 shots. So the jury's going to be having those conversations with themselves. They're going to be sitting, what the heck is that guy talking about? 50 to 100 shots? You can do that in like no time, right? One, get the ball. Another one. You can get 5 shots off in a minute, I would guess. All right. So he presented that today. And now the jury has to decide whether George Floyd was shooting basketball or whether he was doing the other version of hooping. And so I asked this question on Twitter, actually. I said, hey, is there any evidence that George Floyd was at the basketball court earlier in that day? Because presumably he wasn't hooping by himself, right? There should be other people there who were hooping along with him. And you would imagine that they would be playing a game together, unless maybe he was out there just shooting some free throws. But is somebody able to place him there? Or do they have to come and explain what hooping is using his brother because he wasn't actually at a basketball court? So I don't know, right? You can weigh that however you want and come to your own conclusions about it. But I don't like it when the government tries to sort of put some wrapping paper over a big blemish like this one. Oh, hooping? I don't know. We'll just call it basketball. Does he like basketball? Does he have a picture where he's in basketball shorts? Sure, we do. Okay, perfect. Grab it. And let's throw that up there and you're going to explain what that means. Seems a little bit disingenuous to me. Or maybe it's exactly right. I don't know. You can be the judge of that. Maybe they are a big hooping family and they just were hooping out that May 25th before they were, doing whatever they were doing. All right. So last witness of the day, this fella goes by the name of Seth Stoughton. Interesting witness today. Went for a very long time. Very compelling witness from a technical perspective. This guy knew his stuff inside and out. Very, very proficient at his skill set, right? Very, very, very good at what he does. Don't know how well that communicates over to the jury, especially at this point in the trial. They're kind of exhausted, I would guess. They're sort of sick of hearing the same stuff. This guy comes out and once again is talking about use of force. So he is a law professor and he's a former police officer. And he spent a lot of time on this case. He said 130 to 140 hours going through and reconstructing this case because he was anticipating coming in and testifying today. Also been paid something like $25,000 for his work on this, which is not surprising. This is a massive case. That's a lot of time. I think he bills at a reasonable rate. So, my point is the reason they talked about this is because they wanted you to know how much time he sunk into this case. 130, 140 hours or $25,000. I mean, it's a lot of money, right, jurors? We paid him that because that's how respectable he is, and that's how much we appreciate his opinion. And so what he did today is he came out and he walked us through, again, the body cameras. So he put together this little chart, and as we can see, it is a very detailed timeline on what happened. Let me move myself out of the way. You're going to see here, it says that the use of force evaluation, the kneeling on George Floyd's neck and back. And so he's going through frame by frame, and he's sort of fleshing out what the timeline looks like. He says right here, you have the defendant. He's looking at the different threat factors. And so before we go back through that, when I'm talking about use of force expert, he's talking about a lot of these police procedures and whether or not the officers acted reasonably. Did they use reasonable force in an objective format? So would any officer that you look at, if you picked any officer off the street and put him in this situation, would they think that what this officer did was reasonable or not? So it's not subjective. It's not, well, what did Derek Chauvin think was appropriate? No, it's what did the reasonable officer do? Any officer from anywhere in the world, if you put them right there, what would their response be? So what he's saying is, it was opposite of what Derek Chauvin did. Derek Chauvin should have done something differently because an objectively reasonable officer would not have done the things that Chauvin did. This is why he is a use of force expert. To watch what happened, say, no, this is not proper protocol, and then come to a conclusion. So he did that today, and he went through this entirely. So he's identifying different threat factors. He's saying George Floyd is placed prone at this moment in time right here. And he's basically making the argument that everything that takes place in this prone position, everything from this time all the way in red until Floyd is basically dead and Chauvin gets off of him and he's thrown into the back of the gurney, back of the van. All of this is unreasonable, excessive use of force, everything here. Now you're going to notice what Eric Nelson does is he's going to basically try to take this apart a little bit and find different moments and find different expert witnesses who are contradicting this. So if every single thing that happened from point A to point B is unreasonable, excessive force, if he can get another expert witness to just testify that anything that happened in here was okay, then now you have experts who are contradicting themselves. So this is what this guy did. And here is a clip, sort of his conclusion. So this is prosecutor Steve Schlucher, who is now asking him about his conclusions. And so this is near the end of his testimony. They've already been going through this point by point, frame by frame, and analyzing this whole thing second by second. This is Dr. Stoughton's conclusion. So let's listen in.
I'd like you to now please share with the jury what conclusions that you have reached regarding the use of force by the defendant on Mr. Floyd. So I'd ask you first, you have an opinion to a reasonable degree of professional certainty as to whether the type of force used by the defendant on George Floyd on May 25, 2020 constituted deadly force.
I do, yes.
And what is that opinion?
That it did. The use of force had the foreseeable effect and a substantial likelihood of resulting in death or great bodily harm.
Do you have an opinion to a reasonable degree of professional certainty as to whether the type of force used by the defendant on George Floyd on May 25, 2020 was reasonable as viewed by a reasonable police officer on the scene?
I do have such an opinion, yes.
What is that opinion?
Both the knee across Mr. Floyd's neck and the prone restraint were unreasonable, excessive, and contrary to generally accepted police practices.
When, in your opinion, did the unreasonable force begin?
When Mr. Floyd was initially put into the prone restraint position and when the defendant's knee was placed onto his neck.
And when did it end?
When the defendant's knee was lifted off of Mr. Floyd and he was taken out of the prone restraint position.
Do you have an opinion to a degree of reasonable professional certainty as to whether defendant's use of force whereby he restrained Mr. Floyd in that prone position for 9 minutes and 29 seconds on May 25, 2020 was reasonable as viewed by a reasonable police officer on the scene?
Yes.
And what is that opinion?
No reasonable officer would have believed that that was an appropriate, acceptable, or reasonable use of force.
And was the force was the force unreasonable as it started and as it ended?
From the time it was initiated and throughout its duration, yes.
And finally, do you have an opinion to a degree of reasonable professional certainty as to whether the defendant appropriately rendered medical aid to Mr. George Floyd on May 25, 2020 in accordance with generally accepted police practices?
I do, yes.
And what is that opinion?
The failure to render aid to Mr. Floyd, both by taking him out of the prone position and by rendering aid as his increasing medical distress became obvious, was unreasonable and contrary to generally accepted police practices.
Right. Thank you very much, Professor Stoughton. I have no further questions, Your Honor.
Yeah, so that was at the very end, ran through, I think, 90 minutes or so of questioning. Those were his final conclusions. And you can see how sort of articulate and mechanical he was, right? Very, very rehearsed, very practiced statements. And I don't mean that he rehearsed them for this trial, but he's used to speaking this way. This guy testifies a lot, very good at it. And so, is mechanical in his delivery, very careful with his words, very precise, I think is the better way to phrase it. And we can see what he did here. He went through the different criteria. Prosecutor says, hey, was this deadly force? What you saw, was it deadly? Yeah, it was. And he went through the factors. This is deadly. So anything that involves the prone position, basically anything from that timeline that I showed you, that was constituting deadly force. Also talks about whether that force was reasonable or excessive. And this is a pretty important concept in the law, sort of a subjective test versus an objective test. So what would the objective reasonable officer do? If you just said, hey, we're thinking about this hypothetically, that's a reasonable officer. What would that reasonable officer do here? And if the conduct that you see deviates from that reasonableness or from that idealistic person that you are placing in this hypothetical, then they are falling below the standard of care. And this is why we use this in law. It's a much better standard, right? We can't set rules for everybody's subjective interpretation of the rules. Like, think about it with the speed limit, right? What if you just said, well, everybody can go whatever speed limit they think is reasonable? Well, it's very different amongst people, right? How I drive is going to be very different than how my mother drives. We have different interpretations of what is reasonable to do in your car. So we just set a rule. So the objective standard is more like that. It's more based around whatever the objective global standard is based on what we idealize. And if conduct deviates from that, then it is penalized. So what this guy did, Dr. Stoughton, he comes in and he says, no, it's not reasonable. There is no situation where anything that you saw here was reasonable under the objective standard. He also goes on and says it was excessive, and he says that it was excessive and unreasonable and deadly for the entire window, which is a big time, right? We saw that time. We all watched the time on the video. Then he also says that the failure to render aid during that time was also in violation of police protocol and police procedure. And so you've got sort of just this damning cascade of allegations here that this one particular witness says Chauvin did to violate department policy and the standard practices that exist for police agencies across this country. Now, Eric Nelson then comes back out and cross-examines him. So again, when we flesh this out, when we think about this, what the government is doing is it's getting very specific. It's narrowing the scope. It's saying on May 25th with George Floyd, under these circumstances, based on what you saw and what you reviewed, you came to conclusions. Nelson is sort of expanding that out. So he went into some pretty lengthy cross-examination, didn't really get much out of this guy, quite frankly. He's very good. And so it was a little bit difficult for him to even get a good soundbite out of him because his responses were so measured and precise, very precise. And he also did a good job of testifying because when Nelson would ask him something, he would respond with a yes, no, and then jump right into a whole soliloquy about some of the meat that he wanted to add on to the yes or no question. So he's sort of fleshing it out a little bit. Very good job. I think a very, very compelling witness for the government. But Nelson did sort of come out on this one little cross-examination clip that I'm going to play next, where he gets Stoughton to disagree with a different use of force expert. And this is pretty important stuff. If you can start to compare and contrast the expert witnesses, just like what we did with Dr. Tobin, Dr. Baker. One says it's low oxygen asphyxia. The other says it's cardiopulmonary arrest, basically heart failure. Two different witnesses, two different opinions, and they're both government witnesses. So if the defense can do that again with this witness, who's a use of force, reasonable officer, objective standards type of a witness, that's a pretty good win. And he kind of does that. You're going to see here, he's saying, oh, all right, so you say that the prone position was problematic the entirety of that timeline, that entire red bar that I showed you on the graph that they spent most of the afternoon walking through. Yes, I do. Okay, that's funny because Sergeant Steiger, who we heard from previously, disagrees with you. You've got these expert witnesses now that are disagreeing with each other on some pretty important issues. Doesn't look good for the government's case. This is
in terms of those
Nelson.
Tactics, however, when Mr. Floyd, so I want to make sure that we're very clear here. In your position, from your review of the reasonableness of the use of force, it was unreasonable for the officers to put Mr. Floyd in the prone position at all, period, correct?
Yes. At that point, he did not present a threat to the officers or their interests. He did not present a threat of escape. The officers used some amount of force to put him into the car, and I have no issue with that. But putting him in the prone position, especially on the street side of the car, was unreasonable and excessive and contrary to generally accepted police practices.
Reasonable minds can disagree, agreed?
On this particular point, no.
Okay, so Sergeant Steiger, who testified earlier, did you have an opportunity to review his testimony?
I believe yes, I did.
And so his assessment that it was reasonable for the officers to use the prone position in that time, at that time, you would disagree with him?
I disagree. I think putting someone prone is unreasonable there. They are already handcuffed. The prone position is a transitory position used to restrain someone, handcuffs, or I suppose hobbles. In this case, officers took Mr. Floyd out of the car, put him on his knees, and then put him onto his side. And again, if they had stopped there, I would not have any quibble with their actions.
Now, you testified that you described the prone position as transitory in nature.
It is, yes, for 30 years or so, it's been generally accepted.
All right. So the big takeaway there is that he sort of, there was a Sergeant Steiger, I believe is how Nelson said his name, who testified that the prone position may have in fact been appropriate at different parts of the interaction. So he's sort of, getting them to just disagree minor little bits on the margins around the edges. And you saw how Stoughton responded, right? He said, yeah, I would disagree. And he just laid out a whole line of reasoning there. And so the jury's going to have to figure out what to do with that. There are contradictions now from the government's own experts that there are different interpretations on some of these things. And Stoughton kind of shot himself in the foot a little bit, said, Eric Nelson says, hey, reasonable minds can differ on this, right? No, not in this message. Okay, well, that's great because the government's own witness came out and testified differently. So now how do you deal with that? So it's an important thing, and Eric Nelson's doing a good job of sort of fleshing out the differences between the two sides because there is a lot of room for interpretation on all of this stuff as we are finding out. And so that was really it of the Chauvin trial today. The judge did give us some guidance on the future timeline. I think we're going to be closer to being done with this thing this week than many of us even expected. I thought we were going to have more testimony today and this week from the government, but really it's looking like this may be done this week with closing arguments starting next week on Monday. This is Judge Cahill who's giving us some guidance. He's actually talking to the jurors right now, but he's fleshing out what we're looking forward to literally in the next week before deliberations start. Here's Judge Cahill. If you haven't seen him, here he is.
Members of the jury, we will be taking our adjournment for the day, but I wanted to give you an idea of a little bit of time frame now that we're getting closer to the end. We expect that we'll be moving to the defense case tomorrow, and accordingly, we expect that we'll finish all the evidence in this case by the end of the week, possibly with even Friday off. My preference is not to make the attorneys close on Friday because when they close, this case will be submitted to you for deliberation, which means at that time, as we warned you long ago in jury selection, you'll be sequestered. If I were to have closing arguments on Friday, that would mean you'd be sequestered in your weekend, and I don't know if you have any plans. I'm not going to do that. My preference is to give the attorneys more time to prepare their closing arguments and have the closing arguments, we predict, on Monday.
Wow.
At that point, you will be sequestered. So you'll get some more information from the sheriff's deputies regarding that, but expect that you will, when you report for duty on Monday, that it will be followed by sequestration. So pack a bag.
Pack a bag.
But the deputies will give you a little more information. Just wanted to kind of give you that so you can plan your own lives around that. And we will see you tomorrow about 9:15. Thank you. We're in recess.
All right, so that was the end of the day. They're going to be back tomorrow at 9:15, and the judge said pack a bag coming on Monday because sequestration is going to start soon. So let's take a look at some questions. By the way, if you want to ask a question, place to do that is going to your web browser, typing in watchingthewatchers.locals.com, sign up, support the show, join the live chat when we go live and ask a question. Our first one comes from Pato at Locals, says, correct me if I'm wrong, but doesn't the second-degree murder charge carry an element of intent with it? I've listened to quite a lot of testimony as to the cause of death of Mr. Floyd and police policies, but the state practically made no attempt to prove intent. To me, it looks like they didn't even try. What are your thoughts? So good question, Pato. And I don't have the statute in front of me right now, but if I'm not mistaken, I think the second-degree murder charge has a whole section of unintentional murder. And it's really where we're talking about sort of the negligence. In other words, I'm not real sure that anybody here is alleging that Chauvin intended to murder him, like woke up that day and went and intended to murder him. Some people are saying that because I think apparently there's some indication that Chauvin and Floyd had a history together. But of the charges that I have seen, I haven't seen intent as one of them. Now, he had to have intent to go do the thing, so he had to have intent to put his knee on Floyd's neck when we're talking about felony murder. Right, that's one of the murder charges. It's felony murder. So did he intend to kill Floyd? Not sure that that is the case, but did he have intent to put his knee on Floyd's neck or back or shoulder blade or however you want to characterize it? Yeah, he did. And that is about the closest level of intent that I think that we have seen, because I don't think that the statute requires it, at least the statutes that he's been charged with. So take a look at that. I would actually go and look up the full statute, or if you want, take a look at the charging documents for Derek Chauvin. And I think on the second-degree murder charge, the one that you're referencing, I think there is intentional and then there is unintentional. I could be mistaken about that, but it's in there somewhere. So I think you may just be looking at the wrong section of the statute. We also have Jay Bone says the St. Paul mayor said something along the lines of, prison would be a good start, talking about the Chauvin trial at the Wright press conference. That's game, set, and match for mistrial in my book. You're kidding me. The St. Paul mayor said that? Well, that's a pretty irresponsible statement for a mayor, but doesn't surprise me because the rest of the city council there is also irresponsible, so they're in good custody. We got Onion says, Robert, did you see the interview on MSNBC gaslighting the jurors? No, I didn't. Could that be considered jury tampering? We all know that people on the jury, sequestered or not, will probably have seen that. What about the mayhem, not riot in Minnesota? A warm-up. Yeah, I know. It's just like the worst possible thing. I was talking to Miss Faith about this. They're like, could you think up something that would be worse than what happened with Dwayne Wright? Like right in the middle of jury trial for Chauvin. I think it'd be hard to come up with something worse than that. But it is, no, I did not see the interview, Onion, so I just can't comment on it. I apologize. I'm not sure what they were talking about, but it's MSNBC, so it can't be good. We got Liberty or Death says, have you noticed that whenever the Chauvin trial is reported in the media, they only report to the parts that are in the plus column from the prosecution? Seemed to me the media is just lying in wait to cover the riots that will occur regardless of what the verdict is. So I am actually noticing that, Liberty or Death. Last week, I was a little bit unplugged from some of the, I would say, the mainstream media coverage about the Chauvin trial, but I was talking with some people about this, and actually we were on Clubhouse, and I was asking Ma about this, and I said, hey, what's been the coverage looking like? Because I've just really been watching the trial and sort of trying to remain as objective as a defense attorney can be with this stuff, but watching it without a lot of the spin, because I don't need to. I don't need to go to the New York Times or the Washington Post. It's all being live streamed. I don't have to listen to what any of those idiots think about anything. But I did poke around on the New York Times today because I noticed that gap in sort of my perception of what's going on. And I was noticing that, Liberty. I was looking through, and it's all the good stuff for the government. And even when I was even on the New York Times, I was watching somebody's live tweets, and they were saying something like Eric Nelson's trying to corner this witness into, or trying to box this witness into a corner. And I'm thinking, that's not a real friendly framing of what Eric Nelson is doing. You mean defending his client who still maintains the presumption of innocence? Putting up a vigorous and active defense for that person? Or is he trying to box them into a corner? Like, he's doing his job, and they're framing it in a very pejorative fashion, which I think is inappropriate. So yeah, I think if there is, let's say, an acquittal and there's a lot of anger with that throughout this country, I think there's a lot of people who are responsible for that. It's the people who are stoking fires on both sides, when really I think the most appropriate way to handle this is to try to be objective, understand a little bit more about the other arguments that are being proffered, and make a reasonable conclusion, but that's not going to happen. Want to Know says, can the judge hold the mayor in contempt in the Chauvin trial? I don't think so. I don't think that he has ordered the mayor to do anything. And I'm not sure that the mayor has sort of entered into a contempt order is like the court orders you to do something and you don't do it. Right? Go and show up at this or file this motion by this certain time. You don't do it. Court punishes you for that. Or it can be something, that you're violating a very clear court rule or a decorum, whatever's going on in the courtroom. Mayor making a public statement as part of his public office, I don't think that the judge has any wherewithal to go after him. Anki Woe says, today's last witness seemed like he watched previous testimonies and was determined to keep his own narrative, adding a lot of excess explanations, and position rather than just answering Nelson's questions. Is watching the previous witness testimonials usual for a witness to do? It seems like the witness anticipated Nelson's questions and made significant effort not to become the defense's asset. Very good observation there, Anki Woe. I think you sort of saw the same thing that I did, right? I was just mentioning how I thought that this guy was a little bit squirrely. He was very, very assured of himself and did not let Nelson give him yes or no's. Really added a lot of meat onto those, to the ends of those explanations, which served him well. Because he's an expert witness, the judge in this case carved out some leeway for expert witnesses to listen to each other's testimony. And so traditionally, witnesses are not allowed to hear other witnesses' testimony. We actually talked about this last week. There's a federal rule of evidence that says witnesses basically are secluded from each other so that they can't testify in lockstep with one another, right? You want independent testimony from different witnesses. Here, these are expert witnesses, and so they need to sort of know what the other experts are saying because they're specifically being brought in to rebut those other experts. So here, the defense is listening to a lot of these, and the state's government is, the state's witnesses are also listening to the other expert witnesses so that they can intelligently speak and converse about those issues. So I think your observation is right, but the judge has allowed it here for those reasons. Justice First said, did Dr. Baker ever explain how neck compression was a factor in the cause of death? I heard him describe how the stress of capture caused an adrenaline surge, which was a complicating factor, but didn't he testify specifically that he thought the knee did not strangulate the airway or the carotid artery? I sense he was influenced by others to include such vague non-medical term as neck compression. Do you think the defense missed an opportunity to probe him more on this? So I do, actually. I think the defense sort of was off a little bit on his testimony specifically. And I mentioned that when Dr. Tobin, wait. Oh, I thought you were talking about Dr. Tobin. You're talking about Dr. Baker. So I think maybe we're talking about two different people. So Dr. Baker said specifically that he didn't think that any low oxygen or asphyxia was the cause or the mechanism of death. Dr. Baker said specifically that it was the subdual by the law enforcement that caused a cardiopulmonary arrest, but he more attributed it to Floyd's bad heart, really, rather than any type of compression, low oxygen, or any of that stuff. So Dr. Tobin did, however, and I think that the defense, Eric Nelson, missed a little bit on Dr. Tobin, but he did come back and clean it up later. And specifically, it was about some of the other complaints about George Floyd not being able to breathe before any of the four factors that Dr. Tobin went through were ultimately in effect. So I think hopefully I added a little bit on that question, but I think maybe we're crisscrossed. Liberty or Death says, so did Dr. Rich perform the autopsy too, or is he just reading a report? Yeah, he's just reading a report. He's looking at all the stuff that Dr. Baker, who actually did look at the heart and actually did do the report, did. We've got Ma Fox in the house says, I think it's only reasonable to presume he was talking about basketball. I mean, hiding drugs by shoving them in your mouth when you know it's potentially dangerous, as well as not really answering any questions of what are you on, makes me think this idea that Floyd was being honest while also lying all the time is ridiculous. People need to make up their mind what he was trying to do and not say that it's both when it's convenient. Yeah, it's a good point, Mom. And the jury's going to do that. They're going to be the ones who get to tell us what they think. What was hooping, whether that mattered or not. What was he saying on the ground? I didn't take no drugs. I took too many drugs. Remember these things? These are facts that have alternative interpretations. And so the jury is ultimately going to be the finder of the facts, and they're going to tell us what happened. But yeah, it's a good one. It's a good question. Robert Barnes in the house said, did Nelson get into political biases of the medical expert from today? Did Nelson? No, not that I heard. Robert Barnes also, have you ever seen so many state experts disagree with each other? No, so that's a good point. So for those of you who don't know, that's the Robert Barnes in the house, right? You want to make sure you give him a solid follow because he is more plugged in than I think anybody on Twitter when it comes to legal news, and he's got two very good questions. So no, not on a trial this big. State experts like disagreeing with themselves on a number of very important issues. The big one, of course, is the mechanism of death. And so you've got Dr. Tobin, asphyxia, low oxygen. You've got Dr. Baker. Now it's cardiopulmonary arrest caused by arteriosclerosis and other heart conditions. Pretty big, important difference there. Pretty big distinction. Then you bring on today, now you have a use of force expert who says no, that the state's prior witness, Sergeant Steiger, has a different interpretation than I do. And I'm also, right? It's a mess. And so when we start talking about reasonable doubt, Robert knows this as well as I do, as anybody does. It's a very high standard. They've got a big threshold to meet. They've got to prove it beyond a reasonable doubt. And the way we explain this to the jury, it's beyond any doubt that's based in reason. And so if we're having a question about what actually killed George Floyd by the government's own witnesses, that's pretty reasonable doubt, don't you think? But who knows? There's a lot of pressure on them right now. And did Nelson get into the political biases of the medical expert from today? I didn't hear him. I don't think I've heard him get into that with any witness, but I could be mistaken about that. I'm trying to think, is he asking them? I don't think I've heard that at all. But anyways, good to see Mr. Robert Barnes in the house. And hey, they're also on Locals. So if you notice, Robert Barnes is right over there and he's on Locals. So go check him out. It's Viva and Barnes. I think it's vivabarneslaw.locals.com. So go check him out. If you're on Locals already, you want to get plugged in, support some of the other communities there. And that way we can build our own little, contingent away from some of these other yahoos that exist on the internet that want to silence all of us. And so good to see you, Mr. Barnes. Thanks for chiming in here. Hack Consulting is next. Says, if the prosecution presents a turd, does it matter if it was a 25K turd or a 5K turd? It's still a turd. I think the more they expand on how much they spent, the more they are trying to impress the jury, then respect the jury by presenting actual argumentation for the case. Hack, this is a good point, by the way. And I think that this is something that is a little bit underappreciated when it comes to some of this stuff. Dr. Rich today, right? The jury are people, and they don't like when people come in are sort of patronizing to them. And I think we got some of that today. It felt a little bit more patronizing today than some of the other testimony. And it was like they were, Dr. Johnson in particular was kind of talking in a very facile way. And I'm trying to be objective about this, but I just want to point this out. He was sort of talking to them like they were children. And sometimes witnesses will do this. And it's a little bit problematic in my opinion. When they talk to you like, and the heart has two pumps. Think of them like two pumps, and one heart pumps into the other heart pump, and then it goes through these little tubes in your body and distributes the blood. And you just go, yeah, I got that part, right? So why are you talking down to us? Like, just tell us what's going on. And it felt very duplicative. It felt like sort of unnecessary. A lot of the testimony today felt unnecessary to me. And like they were just sort of, hammering home that additional point. At some point in everything you do, you go, all right, enough already.